All right, let's kick it off. Hi, everyone. My name is Sean Whalen. I am one of the co-founders and CEO of HopSkip. For those of you who are not familiar with HopSkip, HopSkip is a software platform that planners use when sourcing room blocks and meeting space at hotel properties. And since our product helps planners and hoteliers manage the proposal and contracting process, we knew that in order to build value-added contract features, we needed legal perspectives from both the planner and the hotel side of the contracting process. So that's why we've been working with Barbara Dunn, who represents group clients, and Sommer, Devlin, who represents hotel clients, to incorporate both perspectives into our product. And at that same time, over the past 8 weeks or so, we've heard from many planners within the planner community that there is a lot of uncertainty right now on how best to navigate current and future event contracts with hotels. So that's why HopSkip decided to sponsor today's session. We wanted to help share both perspectives to the community on how best to navigate event contracts in light of COVID-19. And before I hand it over to Barbara and Lisa, I'll quickly provide an overview of the content that we'll be covering in today's session. Lisa, if you don't mind just switching over to the next slide. Today's session is going to be split into two 30-minute portions. The first section will be Lisa and Barbara providing some knowledge and guidance on how best to manage and handle event contracts with hotels in light of COVID-19. And then the second portion of today's webinar will consist of a Q&A. If anybody has any questions throughout today's presentation, please feel free to ask those anytime using the Q&A function shown in the screenshot in the slide. Also, we will be sending out some live polling questions. The results will be completely anonymous, but we'd love to display those results in real time to you to show you how some of your peers are thinking about some of the same challenges and questions. And the last thing I want to call out, I don't know how many folks have seen the news recently as it relates to Zoom usage, but since there has been a spike in Zoom usage, that's translated to a spike in Zoom hacking, unfortunately. So if our session today gets compromised, we will end it immediately, but we will be sure to send out a recorded version of today's webinar to all registrants and attendees. And with that being said, I'd like to pass it over to Barbara and Lisa, our two presenters for today's presentation, to take it away.
Thanks. Good morning, everybody. Barbara, you want to jump in first and tell everybody about who you are?
Absolutely. Good day, everyone. It's nice to be with you, virtually or otherwise. I'm Barbara Dunn. I'm with the law firm of Barnes & Thornburg, based in Chicago. I'm sure, like many of you, working remote these days, and delighted to be part of HopSkip and to work with my good friend Lisa Sommer, Devlin. So for the last 28 years, I've devoted my practice to representing all types of nonprofit corporations. But of course, those groups, like many of you, have meetings, conventions, and trade shows. So I have a niche practice in this area, representing groups from negotiating, hotel, convention center, all related contracts, to what I've been doing in the last probably 2.5 months, as Lisa I know has from the hotel side, trying to play cleanup and trying to assist our clients in going forward. So I'm looking forward to today's discussion. Again, encourage you to ask questions. And Lisa, I'll turn it to you.
All right, thanks, Barbara. Hi, everybody. I'm Lisa Sommer Devlin. I'm an attorney based in Phoenix, Arizona. I've been practicing law longer than Barbara, but I started out as a litigator, and then starting in the 1990s, I began representing hotels, and I exclusively represent the hotel side, doing contracts, litigation when appropriate, training, and all things related to hotel contracts. Barbara and I would like to start out by emphasizing that while we're delighted to be here with you today and delighted to be sharing information with you, this is not legal advice. This is information about what we've experienced and some tips and some ideas and some impressions of what's going on in the industry. But if you have specific legal issues and specific legal questions, we're going to send you to your personal lawyer because we can't give legal advice in this kind of setting. So with that, we're going to jump in. The basics of force majeure. The key thing to understand is that you don't need a clause in your contract that says anything about force majeure. All you need, if there's truly a force majeure that happens, the law will excuse you. But most people want to have a clause. So Barbara, why don't you talk about what the elements of a standard force majeure clause are?
Yeah, thanks, Lisa. So agree, obviously, the concept of force majeure exists in case law in every state. It exists in different ways, but as Lisa mentioned, the parties are free to negotiate in their contracts force majeure provisions, which are customized to fit their needs. Typically, the two requirements in order to exercise your right, and I will say that once again, exercise your right to cancel without liability, whether you're a group or a hotel, are really two main requirements. So the first requirement is saying that what's going on, in our case, let's use the pandemic, is a force majeure event. And typically that's an easy requirement to meet because most clauses, while they speak to a variety of force majeure type events, they typically have a catch-all statement. Something like, or any other cause beyond the party's control, or including but not limited to, or such as. So usually that's not a concern about a group meeting that requirement, or again, for that matter, the hotel meeting requirement. The second requirement is the harder one to meet, because in that requirement, you have to establish that the force majeure event has a particular impact on your ability to perform the contract. So again, hotel and group, whether it's illegal or impossible, or Lisa, our preferred term, commercially impracticable, essentially saying that, you know, there's this frustration of business purpose for this particular meeting. So it's those two requirements. And Lisa, you know, on my side, the group side, obviously, you know, groups a lot of times have language that simply speaks to illegal or impossible. And I know, you know, talking with you, you know, we know that that's the highest part, you know, where the bar could be set in meeting that requirement.
Yeah, the important thing to keep in mind here is that a force majeure claim is a two-step process. The first thing is you have to have the unexpected event, something that was unforeseeable at the time, fire, flood, whatever it might be. And then you have to have the second element. And that's something we're going to talk about a lot today, because the second element is that standard of impact that Barbara is talking about. You can have a pandemic all day long. That doesn't necessarily make your meeting impossible to go forward. And so every time you have a force majeure claim, there has to be those two elements, the unexpected event, and it has to raise to that standard of impact that's in your clause. So when force majeure, when COVID-19 first started, Barbara and I were in agreement. When we were back in January and February, we did not think that it was a force majeure because of that standard of impact issue. That is, while there was this pandemic, there were people getting sick in other areas of the world, it wasn't impacting meetings here. And so we were telling people it wasn't a force majeure. Barbara, you want to jump in there?
Yeah, Lisa, and I will add the qualifier that, you know, the answer to is it a force majeure event in that case is really, it depends. Does depend on what the contract said, as you mentioned. And if the contract bar was set at illegal or impossible, yes, definitely I agree with you, into February and even into early March. Certainly that was the case. Obviously, on a going forward basis, as unfortunately things got worse, you know, the argument as to force majeure really in any contract became stronger, even if the bar was set at illegal or impossible. And, you know, we've been rolling through this process now, unbelievably now leading into Memorial Day weekend, you know, since early March, some of us working on this since February timeframe. So there have been a ton of developments, and Lisa, you know, you like me, you know, keeping track of the developments as our clients are tracking the developments is a full-time job in and of itself, because things have been changing at a rapid pace. And in the world we speak today, the world is changing, the states are changing, and reopening plans and otherwise, again, are changing. So, we're all dealing, as you all are, with the current set of circumstance. And so the question is still relevant, Lisa, whether this is a force majeure event. And my, response is look at the contract.
Obviously, you have to look at your contract, but the other thing you have to keep in mind is, people are talking about, well, there's a pandemic declared, there's been a state of emergency declared, or something like that. The mere declaration of the pandemic or the state of emergency is not a force majeure. In most cases, a declaration of a state of emergency is a process that has to happen in order to get access to federal or state emergency funds or state or federal emergency procedures. But in and of itself, it's not the force majeure. What the force majeure is when there were changes that resulted in meetings being prohibited. I'm sorry, my dog's barking here. Come here. This is the joy of working at home. Come here. It was the bans on meeting sizes that really prevented the meetings. It was the recommendations against non-essential travel that kept people in their homes, or the stay-at-home orders. Those are the things that caused the force majeure, not the declaration of emergency or the declaration of pandemic.
Yeah, I agree with that, Lisa. And sorry, just to jump in, I agree with that. And I think the point being made there is that, again, it was all about whether the particular thing that happened had that impact on performance. And to your point, it became impossible for those gatherings to happen when that started happening. But again, if you're a group that had commercially impracticable, you might have been able to make that argument a little bit sooner based on the facts and with your group and your meeting time.
Right, and maybe we should focus for a minute on what commercially impracticable really means under the law. And basically, it's a much more complicated analysis than this, and it's based on the particular facts of every circumstance. But commercially impracticable basically means you could still have your event, but the purpose is ruined. For example, the hotel may still be open. I apologize about this. The hotel may still be open, but nobody can come to the meeting because they're all under stay-at-home orders. And so if nobody can show up because they are prohibited from coming there, even though the hotel is still technically open, the purpose of having that event is frustrated, and so you would be excused. You want to add to that, Barbara?
Yeah, absolutely. And that's the framework under which I encourage our groups to really articulate what is the purpose of your meeting or your event, and what's the critical mass, so to speak, that you need in order to fulfill that purpose. We know some meetings have trade show components, some have networking components. A lot of you have meetings that have hands-on training. And so it is important to understand those components. And it was then, and it is still now going forward, important, because as the requirements change, again, that standard of commercially impracticable, how your meeting would be impacted by the force majeure event is definitely going to be something that you're going to need to stand behind. And that's why, having thought that through, Lisa, to the point about the frustration, I jokingly say that we're all frustrated these days, but this frustration of purpose concept is one which is something that definitely exists. And some of you may be saying, well, I don't have that language in my clause. And again, I point you to your legal eagle and say, most states have laws on the books relating to this concept. So whether your contract includes the concept of commercially impracticable, Lisa, some state laws do provide case law around that too. So something groups should talk about with their legal eagle.
Another thing to think about, Barbara mentioned having something in your contract about the purpose of your event. It's also, if there's going to be people that are coming to your event that are critical, it's also important to include that. It's kind of amusing that when this whole thing started, suddenly the hotels were hearing from a lot of customers that said, oh, all of our attendees are international and they no longer can come, and so we are excused from our contract. When the contract was signed, it was for a local dance event or something, and suddenly everybody was going to be from China, and so they were excused from their contract. If you really are expecting international attendees, that should be something you could include in your contract so that everybody knows that that's one of the purposes of your events. Then you're not going to be having those fights down the road. Which kind of leads us into our next concept here, and that is that the law lags behind circumstances. Nothing like this has ever happened before. Even the pandemic of 1918 was very different than this one. And so there's not a lot of case law out there to guide us on what is happening under these circumstances. So there's a lot of things that we just don't know. A lot of people are coming to Barbara and I and saying, well, what's the law on this? And our answer is often, I don't know. I don't know how a judge would look at that. Barbara, what do you want to add to that?
Absolutely, Lisa. I mean, I'm confident that this pandemic will make new case law in a whole variety of sectors. But yet, to your point, that case law may be well down the road. We saw after 9/11, some case law developed out of that, but not likely as much as we're going to see coming out of this pandemic, I'm sure. So, my guidance is really, Lisa, we don't have necessarily anything to compare this to, but it is important in talking with your legal as well, is to really balance the legal issue with the business issue. I mean, we're going to talk a lot about relationships and how important, and all of our, good folks listening on the hotel or the group side know how important the relationships are. The relationships really don't get tested until it's times like this. So I encourage planners, again, hotels, to think about the business implications, as I know you do, Lisa, as well as the potential force majeure legal impact.
Right, because when we got into the stay-at-home orders and the limitations or prohibitions on meeting size, absolutely, at that point it became a force majeure. But then we get into the edges of the situation when it's not so clear whether or not the event can go forward. And as Barbara says, the law will eventually catch up to this situation, but that's going to probably take years, because you're going to have court cases, then there's a result, and then there's an appeal, and then out of that appeal, you get the new law that deals with this particular situation. That's going to be 2, 3, or more years down the road. In the meantime, you have to figure out what you and your business partner are going to do about the situation. So rather than focusing on, is it a force majeure, isn't it, it's better to have a communication with your partner and say, here are the circumstances in which we find ourselves. How can we work together to figure out what's going to happen?
Yeah, Lisa, as you and I have talked about a lot, and those folks on the call have experienced themselves. This is an incredibly emotional time for everyone, personally and professionally. And of course, suffice it to say, we should have said at the outset, obviously, hoping all of you and your families are safe, because we understand that that's ultimately the key comment here is, but take that into account when you are reaching out to your business partner, because it is important. There's obviously been devastation across the hospitality industry, and that's an understatement, I know. But keep that in mind, Lisa. I know I've encouraged our clients sometimes, if they received a terse email or they sent one and not running past it, it's an emotional time, and it's okay to say that.
And it is, and that's true. And again, Barbara and I will always say this: it's better to ask to have a conversation than to make a demand or draw a line in the sand. Other issues that have come up is after the fact claims. By that I mean you had an event scheduled for July of this year, and back in January you decided for business reasons that you weren't going to have the event, and you canceled and probably paid your cancellation damages, and now it turns out that you can't go forward because there's meeting restrictions in place. Can you go back and say, hey, it turns out it's a force majeure, I want my money back? In general, the law on that would say no. If at the time you canceled, it was not due to a force majeure, and then later that develops, you can't go back and collect your money. Barbara?
Yeah, and again, that's why it's so important, Lisa, again, either side of the aisle, that you take a snapshot on the day that you make the decision. And you take the snapshot of the facts and circumstances surrounding, the pandemic, as well as the local community, the group, et cetera. And that's the snapshot that you're going to have to stand behind as you go forward, regardless. None of us, unfortunately, know when this will clear and how long it will take and everything else that's related to that. But at the end of the day, it's that snapshot that becomes the most critical component.
Another thing that has happened during this situation is that governments in various jurisdictions have actually gone in and taken over hotels to house either healthcare workers or people that are sick, or military personnel that are coming home from deployments that they have to quarantine. And that may impact meetings going forward, because suddenly the hotel can't host the events because they've been taken over by the government. That's kind of a different animal of force majeure that would excuse the hotel. Similar, we've had hotel buyouts for similar reasons, especially in California. There have been a lot of buyouts where people want to come in and take over in order to protect people. Again, free rooms for medical professionals. So all those things are out there. Barbara, have you been dealing with those kinds of situations?
Yeah, absolutely. So, you know, we know a lot of the convention centers have, and some still are being used as field hospitals. So, you know, the tie-in for those of you who use a convention center in conjunction with hotels for your meeting, yes, very much oftentimes receiving notice from the centers that they can't perform. Similarly, the same with hotels for those reasons too. So it does run both ways. And, you know, again, it's a most unusual circumstance that it's nationwide. Some of these, you know, takings and you know, state of emergencies, if we've had hurricanes or things like that, are often limited in geographic area, but also time duration. Again, we don't necessarily see that here, so it makes it all the more unique.
So going forward, what's going to happen? And we don't really know. You know, it's been interesting the past couple of weeks to see that citizens are demanding that that states reopen when the states aren't necessarily ready to do that. And how is that going to impact events going forward? We're not really sure. Are the states ready? You know, there's a great deal of argument about what states are ready, and there's some states that didn't shut down that are now having outbreaks. So we're not really sure. Not everybody's going to be on the same schedule, and that's going to create another layer of issues because, say, you know, your meetings in Arizona where I live, and Arizona has reopened. But what happens if the attendees are from New York and New York hasn't reopened? How are you approaching that, Barbara?
Yeah, no, that's very much the case. I would say it's not just geographic to the location of the meeting, it's geographic as to where people are coming from. And, you know, obviously, as you mentioned at the outset, Lisa, with regard to international restrictions on travel, you know, I say to clients, we all know that Canada and Mexico are not part of the United States. That includes those countries because we know we have border restrictions there too. So it definitely plays a part in the overall snapshot, if you will. And again, that has to be taken into account as well.
So when we're looking to events starting in this summer, June, July, beyond, I'm already getting cancellations for events that are scheduled in February. And the response to that is, it's way too soon to say that. Nobody can claim now that it will be impossible to have an event in February. When you're getting closer in for June, July, and August, instead of, again, drawing a line in the sand, you should be talking with your partners about things like, how long will it take us to plan this event? When will the hotel be open if the hotel is not currently operational? What staff are you going to have in place to help plan and execute this event? It's a discussion. It's not a line in the sand because, again, nobody can say at this point whether states are going to be open in June or July or August or what's going to happen. And it keeps changing. You know, Governor Newsom in California changes his mind about when things are going to happen. So you can't even look at what a state is saying today and rely on that for what's going to be happening tomorrow. Barbara, how are you approaching it with your clients?
Yeah, Lisa, you said this in your remarks, and that is, you know, how long is it going to take to plan the meeting or move the meeting? Again, a small meeting may be much more nimble to wait and cancel closer in than a very, very 10,000 person trade show citywide. So, you know, there are those considerations as well that need to take place. But I agree with the approach as to the discussion. I agree with the questions that really should be asked on both sides of the aisle, both with regard to, you know, what the group is doing, what's happening to the group side and their meeting, and the same on the hotel side. You know, again, we know there have been closures, we know there have been takeovers, we know there obviously have been staff layoffs and furloughs, and all of that impacts both parties' ability to perform the contract. So it's something that's reasonable. And yes, I definitely agree, as we've talked about, Lisa, approaching that as a discussion, not a demand.
And again, as part of that discussion, I've had customers come to me and say, our marketing takes X amount of months and X amount of time because of our sponsors and other issues. And so even if the state opened tomorrow, our event in whatever month, we couldn't pull it off in the amount of time that we have left. I'm not saying I necessarily agree with them, but it's a conversation that makes sense rather than saying it's impossible for us to have our meeting in October, because we can't say that, but you can say there may be other factors that are frustrating the purpose of your event. Again, a discussion rather than a demand.
Agree.
what to expect going forward. I think one of the biggest challenges that we're talking about now is getting hotels reopened. They're going to have to get their staff back in. They're going to have to just operationally ramp up. There's all kinds of challenges involved in that, just, you know, from cleaning the hotel to get it ready to reopen, to get everything, the fountains filled, getting food on premises, all those day-to-day things they have to do. And then on top of it, they're going to have to address how things are going to be different in a post-COVID situation. You know, what kinds of sanitation, what kinds of social distancing, and all those things are, to a great extent, still up in the air. They also have to manage their cash flow, which, as you can imagine, has been decimated. And as I said, dealing with the distancing. And the cleaning and disinfecting is going to be a real challenge, and they're waiting to get more information from the government as to what it is they're going to be able to do. There's also going to be some venues that will never reopen. I've already had several hotels that have come to me and said, look, we were having financial difficulty for one reason or the other before this happened, and this just pushed us over the edge. And so now they're going to have to be moving all those events that they had booked in the future. And the question will become, are they going to be responsible for the damages that are suffered by those groups that they have to move because they're closing? Are they closing because of a force majeure, or are they closing for business reason? That's going to be a legal issue. Barbara?
Yeah, I agree. And Lisa, just picking up on the last bullet here on the reasonable assurances, for all those reasons that you just mentioned, it is most reasonable for the group to ask the hotels about the assurances. And I would add to that, you know, the financial difficulties, I think, incorporated within that cash flow comment, Lisa, absolutely. And groups that, you know, are paying deposits or have paid deposits, and, you know, there are lots of challenges in terms of whether they're due those back and all the rest. But at the end of the day, it's the performance of the contract, all the things that you mentioned. So for groups looking ahead, definitely asking your hotel, your partners on the hotel or venue side about these items. You know, we'll call them generally reasonable assurances, that you telling me that you can perform the contract. And I can ask you whether you can perform the contract. And by the way, groups, the hotel can ask you the same too. And let's face it, Lisa, unfortunately, just as you've said, on the hotel side, a lot of venues not opening, a lot of groups may not likely stay in business as a result of this. So those assurances on both sides become very important. And those are conversations, again, conversations, not demands, but conversations that need to be had, and those sooner the better. You know, I'd said to clients that come and say, is it too early to talk about? It's never too early to talk about an upcoming meeting. You know, what we're talking about, it might be different, you know, whether it's a cancellation 2 years down the road versus just talking about, hey, we might want to do some bob and weave maneuvers, or we might have to as a result of what the pandemic has done to our group or our company.
And when you're talking about those assurances, as part of that discussion from both sides, you may want to talk about a go, no-go date and say, look, we're not saying whether it will be possible or impossible in August, but let's agree we're gonna get together on July 1 or whatever date you can agree on. And at that point, we're gonna decide based on circumstances at that point, is this a go or a no-go? Because both sides have to be able to prepare for these events. And at some point, they're gonna have to say, you know, we don't know, and since we don't know, we're going to have to agree that we're not going to go forward, and that's okay too. But so many customers that I'm hearing from now are saying, we're not coming in October, we can't come in October. My hotels are answering, we're going to be ready for you in October, so it's too early. So instead of having that fight, why don't you say, we're concerned about October, when are we going to have a meeting to discuss and make a final decision? That's a better way to approach it than saying, we're not coming. Agreed, Barbara?
Absolutely.
So again, how to approach situations. These claims are not worth litigating. We've had, as Barbara said, a lot of really emotional conversations. Even Barbara and I, who are supposed to be, you know, lawyers and not get involved in this, but there's been very, very many emotional conversations, drawing lines in the sand, saying, I'm never going to pay you, or I'm never going to do this. I'll see you in court. It's not going to be worth it, because as we said, it's going to take years for the law to catch up with this situation. There's too many unanswered questions, and as I'm telling my hotels, and I'm sure Barbara's telling her customer clients, you don't want to be the one to litigate this and get the answer that you don't like. So what does that mean? Try and come to business solutions. And I think everybody's been doing a good job of trying that instead of getting into these drawing lines in the sand, because you don't want to wait for 2 or 3 years to see what the appellate court is going to say and find out that you made the wrong choice. Barbara?
Yeah, I agree, Lisa. I think that one of the main questions and concerns that groups have, and I'm sure hotels have as well, is the potential of a claim being brought against them. And, I know the point with regard to litigating and not getting the outcome you want, and I agree that that could certainly happen as well from the group side. But, many a client has asked, I haven't heard from the hotel after I gave my notice of cancellation letter. What should I do? And my response is, you stand behind the notice. If the hotel would choose to challenge it, so be it, then we'll address it. But just because they haven't challenged it now, I think Lisa, doesn't mean they won't. Some groups would like to have it tied up in a bow and get the hotel to acknowledge no cancellation fees, etc. But I've told my clients, don't necessarily be prepared that a hotel would provide that, because again, they're looking at potential options going forward. So do what's in the best interest of your organization, make the decision that's founded in the contract, check with your legal, and then you go forward. And if it comes knocking at your door again, we'll deal with it then. If it doesn't, let the dog sleep. Speaking of dogs, Lisa, I'm hoping yours says.
Speaking of my dog, who I'm going to choke after this. Not really. Barbara's right, and just so you understand, if a hotel is disputing, or whichever side is disputing the other side's position on this, and you're agreeing to disagree, the statute of limitations for filing a claim for a breach of contract can be 4 or 6 or as many as 8 years, depending on what state you're in. So if you send a notice to the hotel saying, we're claiming force majeure, and the hotel doesn't say anything, they don't have any obligation to say anything. They can wait up to the end of that statute of limitations to make a decision as to whether or not they're going to sue you. That's not the answer you want, but that's the reality of how the law works, which is why, going back to these settlement situations that we're discussing, it's far better to reach some deal now and know that you have tied it up with a bow, you've reached agreement, and there's not going to be a claim that suddenly pops up years later. Right,
absolutely, absolutely. And if your resolution you reach is to move the meeting to an alternate date, and you do an amendment to the contract, then you make sure you have language in there which says that, just to that, Lisa, so that in lieu of cancellation fees due for that meeting, the group is booking this meeting. And I think that's the component that does become important, and it can be lost. But I've seen many a group, not at my recommendation, keep poking the dog. And guess what? When the dog wakes up, they might send you a cancellation fee invoice. So that's probably not what you want. So, all those reasons, Lisa, you make the decision and move on, and you hope to keep the relationship going forward.
Yeah, I think it's important to consider the hardships being faced by both parties. Everybody, as Barbara has said, is going through an emotional time, but you have to remember that this has been just as devastating for the hotel industry as it has been for your organization. So always try and look at both sides. And as Barbara and I always say, whenever we give these kinds of presentations, it's always better to come hand in hand and say, let's have a conversation, rather than to say, this is our position and we're not backing down. Right, Barbara?
Absolutely. And again, I mentioned the relationship aspect. Again, I can't emphasize that enough. And many a group has said to me, but I've been a good partner. I want to be a good partner going forward. And I'm sure, Lisa, your hotel clients have said the same to you. And that's important, and that's okay to say that. Again, the definition of what a good partner is changing, unfortunately, given a circumstance that neither party has ever dealt with. So, don't lose sight of that, in the going forward process, because I do think that's important. Unfortunately, our memories are long when we have a bad experience, and that goes, again, both ways. So, we want to keep this front and center, that, we're in this for the long haul, and hopefully many of you, like me, have, 9 lives at least in the industry. And so we'd all want to keep that reputation intact.
And remember, a good partner does not mean that you get everything you want. It means, they always say in litigation, a good settlement is one in which both parties feel like they didn't really get what they wanted. So both of you are feeling a little bit of pain. That's a good partnership. It's not a good partnership where where one side gets everything they want and the other side doesn't. So keep that in mind. Again, we've already kind of touched on this. Remember that you have to properly document whatever happens in your agreement. And while we don't like to recommend getting lawyers involved, if you don't have to, this may be a stage where it's important to do that, because if you don't cross all your I's, or dot your I's and cross your T's, you may end up where you haven't properly addressed everything. Have you seen that happening, Barbara?
no question. I've talked to a number of clients who reached a deal and I said, oh, did you get that in writing? Well, no, we kind of left it to a handshake deal. I was like, oh, that's great. Well, let's go ahead and get it in writing. So yes, I mean, some of you have to backtrack a little bit. Some of the documentation have seen is not ideal. Again, you know, talk to your legal. You may not want to rock the boat if it's all hunky-dory, but you know, if you want that confidence, and getting that type of language as closure is really what the legal eagles are going to look at and what your auditors are going to look at too.
Well, and something to keep in mind is I've seen lots of rebookings that are going on where they're moving an event from April of this year to maybe April of 2021. And I see a lot of situations where they're not thinking about what happens if the event in April 21 doesn't take place. It either gets canceled, it has attrition, it has other problems, or God forbid there's still COVID-19 causing issues. You need to think about not only what's happening with the initial event, but what happens if the subsequent event doesn't meet its commitments. So those are the kinds of things I'm not seeing addressed in all of this documentation. Something to think about. Always remember that emails and texts are not binding. If you're amending your contract, and by the way, this is a pet peeve of mine, it's an amendment, it's not an addendum. If you are amending your contract, it's not going to be binding if you make a deal via email or a text. You can attach a document to an email that both parties sign, and that would be valid. But just saying in an email, we've agreed you're going to move to April of 21 is not binding. I already said it's an amendment, not an addendum. And it's very important to make sure that both parties understand and agree on those elements. What do you want to add to that, Barbara?
Lisa, I agree with you. I would say though, if a client had an email or a chain that essentially said that, I'd rather take that than nothing at all. Sure. But again, in an ideal world, yes, having the documents be signed is important, and yes, calling that an amendment versus an addendum. Is just something that folks will get around. And, I agree as well, Lisa, although I don't necessarily want that to be the case, that if a meeting is rebooked, there's the consideration of the subsequent meeting having been canceled or attrition or whatever the case may be. I understand it is an issue that hotels may ask about. So it is something that the group should be prepared as to how it would want to respond in an amended contract. Because again, I'd never want group to feel that they, don't have the power to negotiate on the amendment. Obviously, both parties have to negotiate on that. So it's something to keep in mind as well.
When it comes to return of deposits, under the law of force majeure, if there's truly a force majeure and you are excused from your contract, it's a termination of the contract. And a termination means that it's as if it never happened. That would mean that the deposits need to be refunded. You don't need to have that language in the contract. That's just the law. Now, the problem that I think everybody's seeing at this point is because hotels are not operating and because hotels don't have cash flow, deposits are being refunded very slowly. And that's just the nature of the situation. And everybody's got to be patient about that, because the hotels understand their obligation, but you can't write a check if there's nothing in the account. So that's out there. It's something to think about. And it's just something that's going to have to be dealt with going forward.
Yeah, I agree, Lisa. One I add on there would be, remember that groups are still legally obligated to pay for any fees for goods or services that were provided to that date of termination. In a hotel contract, typically there's not the case, but any other vendor contracts for your meetings, that is something you definitely need to be prepared that the vendor would be entitled to get payment for what work it did up until the point of termination.
And that's a very good point, because especially for events that were taking place in March, there have been a number of situations where the group really waited until the last minute to pull the plug on the event, and the hotel had already scheduled all the labor, had already bought all the food, had really incurred some significant costs getting ready for that event, and then the group pulled the plug at the last minute. That would be a circumstance where, as Barbara says, you would be obligated to pay for those additional costs incurred. So it's something to keep in mind. Again, I know we're beating this dead horse, but you should be having conversations and talking to the hotel about, when do you need to order the food? We're thinking we might have to do this. Can you hold off while we make a decision? Work together rather than expect the hotel to eat those expenses incurred. And now the big question, are changes to clauses needed? A lot of people think that an unprecedented situation requires a new approach. I don't think so much. I don't think so much. I think the standard under the law is still illegal or impossible or potentially commercially impracticable. If the facts make those things true, then you don't need a new clause. Barbara, you may be looking at it differently.
No, not at all. I mean, I completely agree. In fact, I'm proud to say I'd stand behind all the clauses that I might have drafted 10 years ago for clients that sign meetings in advance. I mean, again, go back to the two components. You know, you've got your grocery list of bad things with your catch-all statement, and you have the standard of impact set as at commercially impracticable. That's going to serve you well. Are there ways you could sort of gild the proverbial lily? Perhaps. You know, obviously circumstances that I've seen of late, a concern that if I rebook a meeting now, it's going to be considered a pre-existing condition. And then if I have to cancel, gosh forbid, again on a pandemic continuing into next year, I'm foreclosed from raising that issue. So that's one that's come up. I think another issue that's come up, is you alluded to this earlier, Lisa, is the fact that at the time the decision is made, you know, the force majeure event, whether it's actually in fact going to be in place during the time frame of the meeting. Again, if the parties can meet the requirements of the clause, they can enact the clause. So what happens later isn't necessarily relevant, but you know, again, do you want to cut some of that off at the pass? Maybe. I just don't. I really don't see a need to change things. And again, I've seen some revised clauses, and you know, Lisa, my groups are trying to make them as robust as possible, and I'm sure I know a lot of your hotel clients are trying to close that loop to make it as tight, so, you know, whether you could even thread that needle. So that's not the way to react. It would be my overall statement.
And I want you all to notice that this was the attorney that represents groups saying that. So she's the one saying you don't.
As long as they have good language, right?
You know, I always say that a force majeure is a lot like what the Supreme Court said about pornography. It's difficult to define, but I know it when I see it. And that's really true with the force majeure. If you really can't have the meeting, everybody's going to know that. That's exactly what happened in March when everything was shut down. Hotels weren't arguing with people about their March events because they couldn't have the event. Nobody could come, nobody could travel. We understood that. The problem that we have is when you're beyond that clear and unequivocal situation. And that's why hotels are so resistant to put in bigger clauses with bigger laundry lists, because oftentimes it seems like the groups forget the two-element standard or the two-part standard of force majeure. The thing happens and it makes performance illegal or impossible. As Barbara's saying, illegal or impossible is out there. It's going to protect you. And if you start adding in all kinds of things that are gilding the lily, as Barbara says, that opens up opportunities for more arguments about whether or not the force majeure is there. That's why we like to keep those clauses narrow and tight. And certainly, as Barbara said, customers are coming up with clauses. I have seen clauses all over the board on this situation. I've been given clauses that say, oh, so-and-so approved this, or so-and-so is recommending that, and it turns out it's not true. Be very cautious about those kinds of things. And as Barbara and I always like to say, bad clauses are born of bad experiences. Whenever you see a really long renovation clause or a really long confidentiality clause or whatever it might be, the first question I always ask is, what went wrong at your last meeting? Because now you're trying to come up with this new clause so that that never happens to you again. And as Barbara and I are saying, I don't think you need to do new clauses as a result of this. You want to add to that, Barbara?
No, just to bolster that. And I know, Lisa, that we're just racing through our time. I know we have a lot of questions too. So I know, Sean, I know you've been watching the queue of questions come in. A lot of you had asked questions in advance as well. So, you know, maybe Lisa, we can dive into a few of those and then do some closing remarks.
Perfect. Yeah, Greg, you want to hit us off with some questions collected from the audience?
Yeah, before we get started, thanks everybody for joining. We've had some really great feedback, and thanks Lisa and Barbara for the talk so far. I'm going to go through some of the questions that we've been collecting both in advance and during the session. Number one, will hotels be open to new types of clauses that allow groups to claim force majeure months in advance, or that reduce the group's minimums if it goes forward with a questionable event and ends up having less attendance?
Hotels are going to be flexible in the short run, perhaps for the fall maybe, and maybe early into 2021. What I'm seeing being requested are clauses for events that are scheduled way down the road, and hotels are not going to be as flexible about that. The reality always is that a hotel would rather have a meeting than not have a meeting. And so if you're looking at an event in October and you come to the hotel and say, look, here's the problem we're having, they're going to want to work with you. They're not going to want to hold you to an attrition clause that was designed at a time when we thought the economy was going to be going great. So they're going to work with you, but they're not going to accept all kinds of these clauses that I'm seeing that really go overboard in giving the group a free pass. A contract is a shared risk, and both sides are taking a risk that it may not go the way they want to. So perhaps you can build in some opportunities for flexibility, but don't expect contracts to be changing going forward forever as a result of this.
Great, thank you. The next one is, what are the legal and business issues involved when a group is considering whether to cancel an event scheduled at a convention center and has hotel contracts with no attrition liability clauses?
Yeah, Lisa, I'll take this one. First of all, no attrition. Hopefully that doesn't mean they don't have a clause in their hotel contract that either they say no attrition or that they leave it to silence. Because remember, you don't want to leave it to silence. If you leave it to silence, you're responsible for 100% of the block. So if you're going to have no attrition, you need to say that. And many of you have heard me say over the years that you're much better off having a robust attrition provision in the contract and keeping it in there. Having said that, a lot of folks say, well, if I use 1 or 2 rooms, then does that really matter? I could cancel my hotel contracts if I'm not required to pick up. You may have liability at the convention center as well. I don't think that's a good strategy. My recommendation to groups, whether it's a headquarters hotel contract or an overflow contract, you have to treat it the same with regard to force majeure. If you can terminate it, you terminate on that basis, regardless of whether you have attrition liability at that property or not. But Lisa, I know you and I have talked a lot about this over the years on, these no attrition clauses or not even having a clause. And it is something that I think groups should think carefully about. As things may shift to a buyer's market in some places going forward, that doesn't mean, I think we just saw an industry article on this a day or so ago, that the no attrition is back, and that doesn't mean you leave it to silence. So we have to be very mindful of the impact of that. Would you agree, Lisa?
I totally agree. Again, I want to emphasize what Barbara says. If your contract says nothing about attrition, that means you're responsible for 100% of the block. If your contract has a clause that says you will not owe in the event you do not fill your block, I think that's a very bad idea, because it brings into question the enforceability of the entire contract. And that means that the hotel can cancel the group and not owe the group anything, because it was never an enforceable contract in the first place. So no attrition is not a good idea from either of our perspectives. Attrition is something you can negotiate. There's standards that people expect in the industry, whether it's 10% or 20% that they can wash without having to pay anything. Maybe instead of a no attrition clause, you negotiate a clause that gives you a much lower threshold, as Barbara said. But avoid no attrition clauses. Not a good idea.
All right, thanks. Next one, what would be some mutually agreeable terms in a force majeure provision for both the group and the hotel?
Yeah, I think we just kind of identified those, Lisa. I was just going to say, again, look at your clauses. You've got the grocery list. You don't have to panic if you don't have pandemic on it, because you probably have, or any other cause beyond the party's control. So have a grocery list that makes sense, have a catch-all, and have a standard of impact that you can live with, Lisa. Do one better than illegal or impossible.
Okay. I've heard.
Yeah, I agree with Barbara. Shorter and sweeter is better. I'm seeing customers coming in with wanting to put in pandemic or epidemic or other words. Hotels are going to push back on that, because a pandemic is a fact. It's not a cause. The fact that there's a pandemic doesn't necessarily mean that your event can't go forward. So hotels want to put in things about, meeting size restrictions, something like that would be more agreeable. Pandemic and epidemic are probably not going to be agreeable.
Yeah. And Lisa, just picking up on the meeting size piece, and knowing that we may or may not have a question coming up on this piece, obviously the concern going forward is the fact that even if a group has a smaller footprint, it actually for rooms or food and beverage. It actually has a larger footprint if we account for social distancing. So, you know, I think there's a strategy there in that those discussions that we've talked about having with your business partner. Talk about the function space. We're seeing new guidance coming out about meeting room layouts and things like that. But Lisa, I think there's some flexibility, again, for both sides that could be put into the contract to account for that without clogging up the force majeure clause.
I agree. Yeah, and I have seen separate clauses that people are putting in saying, in the event that there are government mandates that limit or that require social distancing or something like that, that the parties will work together to revise the contract to adhere to those requirements, and, you know, we'll do so without liability or whatever it might be.
Okay. This one might be a little bit of a variation on things that we've talked about, but what will happen if the venue is open but social distancing requirements impact the number of participants?
I think that's kind of what we just talked about. If the venue's open but there are new mandates, you know, everybody's obligated to comply with the law, and hotels are going to do that and groups are going to do that. So if the law is prohibiting you from meeting your minimum commitment, I think you're going to be excused from that. Agree, Barbara?
Yeah, no, I do. Lisa, there's going to be a line at some point that's going to go from social distancing requirements to social distancing recommendations. And that's the pivot part that concerns me. I mean, believe me, I want things to improve. Don't get me wrong. If it does become a recommendation, but it does, from a group's perspective, it adds that additional nuance there as to how that would impact their meeting.
Okay. I know we have a lot of independent planners in the office or in the audience. As an independent planner, how do I protect myself if I assist a client with a contract and it turns out that the final language is not the most favorable to the client?
The best way to protect yourself, sorry, I'll just jump in. The best way to protect yourself is have a contract. I can't tell you how many independent planners I talk to that don't have a contract with their client. Again, you know, there's risk in here. You do your best to negotiate contracts, but, you know, I have said to many a client and many an independent planner that just because you're dealing with a clause right now, which isn't favorable to the group and the context of force majeure, doesn't mean you did a bad job in negotiating. I mean, we're coming off of, and maybe still have 10 years of a seller's market. So, you know, you may have had to make concessions during the negotiation, but if you're concerned about it, document it with the client. I think that's most important, Lisa, because otherwise, you know, and hotels, I know, Lisa, don't want to get drawn into these disputes with the clients and the independent planners.
Well, and, you know, oftentimes you'll hear somebody say, well, I've used this clause with this other hotel. Every negotiation is different based on the business considerations, a lot of different factors that go into it. And so when you, as a planner, are negotiating a clause with a hotel, you may give on this clause in this circumstance because in exchange you got something else that you really wanted. That's what negotiations are about. And as Barbara said, if you documented that, yes, I knew I was taking a risk here, but in exchange, I got you these other things that helped you more, and I didn't think the odds were that good that this was going to go bad and this clause would come into play, then that's okay. Another thing as a planner you should be thinking about is, are you going to have liability insurance so that in the event that you get sued for something that you do, you'll have something to back you up and protect you in the event of that lawsuit.
Yeah, and then to that end, Lisa, have you incorporated your business? That's a big deal because you have a layer of protection against you and your personal assets on that. I will say, and you brought this up in your comments, the two words that should never come up during any negotiation are never and always. Neither party wants to hear those. So, you know, the saying never say never and never say always are good advice. And I've heard a lot on both sides of the aisle. And again, we just have to throw those out the window and you know, come to the negotiation table hat in hand, really, on both sides.
We got another question?
One more. So should I consider modifying the deposit or master bill language in my contract?
That's really to you, Barbara, I think.
Yeah, I would say, you know, a lot of you I've talked to, a lot of groups I've talked to, they maybe have not paid a deposit because they have worked with the property before, they have good credit, so they haven't paid a deposit. You know, certainly I could see hotels needing to collect deposits at the outset, and if that's the business choice that you want to make, again, the group certainly could negotiate what that amount is. There's some language though, Lisa, that does concern me that I see often tucked into a master account or billing language about groups change in financial circumstances as a means for the hotel to sort of pull the rug out from under the group and cancel on the group. And, you know, I understand the business case for that, but I do say there should be careful attention, as always, on those clauses regarding deposits and regarding master account bills and any implications if there isn't the payment of either those, or there's a disputed charge and things like that, because that comes up all the time. But now I think we're likely to see different language added in there.
Yeah, I think everybody's going to be looking at those business terms and seeing how they want to change them because of the experiences that they've had through all this. And I think that there's no clear answer on how that's going to happen. Again, it will be a case-by-case basis. When Barbara talks about those deposit issues, I've represented lots of hotels where it became clear to them that the group did not have the money to pay for the event they were going to have. And the hotel found itself with no ability to collect additional deposits and protect itself. And when people say, well, my entity has great credit and we've always been paying our bills on time, I always say, yes, I remember Enron. You know, so any business can go under, any business can have a change in its credit status, and hotels have that provisions to protect themselves when they see those slow trains coming. So it's a negotiation, definitely.
All right, thank you.
All right, so to wrap up today's webinar, at least if you don't mind flipping to the next slide, I'd like to give a special thank you to both Barbara and Lisa for being awesome presenters for today's presentation. I hope everyone gained a lot. And thank you all to you for attending. You'll automatically receive an email early next week with a link to the recording. And lastly, in efforts to help out while we all deal with budget and time pressures, HopSkip is currently running a promotion to allow planners to use all of the HopSkip premium features at no cost for your first 3 RFPs or for 3 months after sending your first RFP. And we'd love the opportunity to show you the platform and hear any feedback that you might have on today's session. If so, please feel free to contact us at info@myhopskip.com. And thank you again very much. Have an awesome day and a great weekend. Thanks, guys.
Thank you.
Bye, thanks.